before lunch, but we could just.
Hi everyone, my name is Karen Tereposky. I'm an employment lawyer at Sanford Tumarkin in Calgary, Alberta, and I'm here today to answer your questions about employment law, human rights, and such. So as we're waiting for those questions to come in, which I need to open my chat window, we can chat a little bit about some employment law things that are in the news. As always, it's usually the same sorts of things where companies are, doing mass layoffs or downsizing operations and that kind of thing, and employees are losing their jobs and obviously wondering about what their rights are in those situations. In the news recently, we've had a few companies that are downsizing operations, and as a result, employees are losing their jobs. So that's unfortunate. The one that's been in the news is MasterCard. That's it's laying off 4% of their full-time staff this year. In that situation, obviously employees are pretty concerned about whether they're going to be one of that 4%. And really, all you need to know in that situation is you are entitled to severance. It doesn't matter if the company is downsizing operations. There is severance entitlement because you're losing your job, and what happens there is that you need to be bridged to your next comparable employment. So your rights to severance don't change just because the company is in a bad spot or losing money, and you can always check on what those severance entitlements are by using our website and our Pocket Employment Lawyer, which gives you a good idea of what you could expect if you are getting severanced out. That's on our website. So looks like we do have some questions coming in here. So the first one looks like it is from YouTube. If an employee was rejected from getting hired because of a human rights violation and wants the position where there is no criteria for hiring, can the employee get the position? Thank you kindly. In theory, yes, it would require, proof to the Human Rights Commission tribunal that the reason that there was no job offer was because of a protected ground, and the tribunal can only order that sort of relief. Really, practically, it probably is more of a situation where you would have to prove what your damages were as a result of that loss of that job, and you'd be entitled to compensation. But the time that it takes for things to go through human rights, it's likely pretty impractical to actually force an employer to give somebody a job. What usually happens is that there's some sort of damages. There's a judgment for the amount that employee lost because they didn't get that job, and it can be very hard to prove, but worth making a complaint to human rights to see where that goes. Okay, so next question is the same one. That one is from YouTube instead. So the next one, what happens if you get fired just after you give notice to return from a medical leave? So if you haven't actually returned yet in Alberta, you are job protected for, it's 27 weeks now, I believe, per calendar year. If you've given a medical certificate, it's called under the Employment Standards Code, which really is just a medical note that says that you're off on leave for medical reasons, then you invoke the leave under the Employment Standards Code, which is job protected. So the employer cannot terminate under the Employment Standards Code while you're on that leave. If you've just said, now I'm ready to come back, but you haven't actually come back, you're still under that leave. So your job would still be protected. And under the code, the employer actually is obligated to return you in the same or a comparable position. So if you are terminated, that is actually a violation of the Employment Standards Code in Alberta. As well, it could be a human rights violation if the reason you're off on a medical leave relates to a disability. And there's a difference between, being off because, you have the flu and being off because, you have cancer or something, because one of those is a disability and one is just a transient illness. So if your medical leave was related to a disability and that's part of the reason why you are being terminated, there potentially is also a human rights violation there. So there's a couple things wrong with that. What can happen is, we can arrange, like I've had quite a few of these situations where the employer screws up and does this, and we're able to get the employee compensation for, lost wages due to the human rights complaint, due to the breach of the code, and, just plain old severance. So, I would say reach out. We could likely get you a severance there, and hopefully they've offered you something, but it would be worth looking into, because several things are done wrong there if you're terminated in that situation. Another question here. I'm just scrolling up. My husband works in a sales role. His employer recently told everyone they are changing the compensation structure and will be dropping commissions for everyone. How much are they allowed to change it? So, I mean, employers basically, like, they do what they want. It's really not about, how much are they allowed. It's about what's your recourse if they do something wrong, right? So how much are they allowed to change it? I mean, they're not supposed to make material changes to the terms of employment without agreement. Material is considered 20% generally, in terms of compensation. So if there is a change to compensation that's more than 20% and it's not done on proper notice and not done with agreement, where you're signing off and you're getting something in return for that change, then that can be a constructive dismissal, entitling your husband to severance. But I mean, the issue there with a constructive dismissal is, you do have to say, well, I'm resigning because you've changed the terms of my employment as a result of constructive dismissal, or I'm staying on just, to earn the money that I'm going to earn. And then you can claim the difference, the 20%, as your sort of severance if you decide to stay. So it is kind of complicated how to handle those situations. And probably can tell just by how that was worded that it is a bit, it can be hard to navigate. So, if there is a major change to compensation that hasn't been done on, a good amount of notice, or on agreement with being provided with something, a bonus or something to get that change, reach out and get your rights looked at by a lawyer, because it can be a very complicated situation. And if you don't handle it properly, it is really easy to accidentally condone those changes, and then you lose your right to claim constructive dismissal. So, constructive dismissal is quite complicated. I would get some advice on that, on how to navigate it. Next question: if you work in a seasonal job, is it enough for an employer to tell you 1 month before the next season that you are let go? Are seasonal contract workers owed anything like severance? So under the Employment Standards Code, the minimum severance and requirements do not apply to seasonal workers. So there is an exemption for seasonal jobs, for those minimum requirements. However, under what we call the common law, which is what the court set, there can be a severance requirement depending on your circumstances, age, availability of similar employment, etc. So, worth looking into again, as where you sit on that. You can kind of get an idea of what your severance requirement would be, like I said, by trying that pocket employment lawyer that we have online. It's our severance calculator. But generally under the Employment Standards Code, seasonal workers are exempt from what's called termination pay, but there may be sort of a severance requirement set by the courts depending on your circumstances. So I would check that out to see if that applies to you. Next one is, if you work on a cruise line, what employment laws are you subject to? Well, that is an interesting question. definitely not Alberta, since it would be really hard to be on a cruise in Alberta. I think generally where you work is, what laws you're subject to. So the jurisdiction of employment definitely would be complicated in that situation. You're probably in like international waters. So if you have an employment contract, what I would do is look at the terms of that employment contract, because often there will be a choice of laws section in there that says what employment laws or what law you're sort of agreeing to be bound by. It may be in an employment offer. And in those situations, I would imagine that the employer would take care of that by putting it in some sort of employment offer or employment agreement and saying, here's the laws that we are going to get you to agree that we're governed by. It also can be, where the employer's place of business is. Although you're, seeking out or going out on these sort of adventures on the ocean when you're working, there's probably a connection to one office or place where that employment contract is signed, etc. So it could be based on a lot of factors, and it would be dependent on, kind of where the employer is located, what your contract says, and those kinds of things. So not an easy question to answer. And yeah, definitely an interesting one as to which laws would apply in that situation. There's another question from David on Facebook. I'm a carrier. I deliver to provide residential properties, maybe private residential properties. On my scanner, the customer can leave me messages. For example, please leave at my door if I slip and fall on the property due to lack of maintenance, or if they have a dog and the dog bites me and I have lost time at work. Is the homeowner responsible for the company? Wow. Okay. Well, I would say that's a WCB issue. If you are injured at work, generally employers have WCB coverage, so workers' compensation benefits, right? If you're injured at work, which in your case, is when you're out on your route, etc., WCB should be the party responsible. So WCB is basically insurance, and it insures the employer against having to pay for workplace injuries. So I would say probably neither the employer nor the homeowner is responsible. It would likely be something that would be covered by workers' compensation. So that's where I would look first. Any workplace injury, and if your workplace is, out and about, that's considered workplace injury. So your coverage should go there. WCB coverage is really good. They pay, I believe it's up to 90% of salary, and provide with benefits such as, if you don't have health benefits, physio, counseling, etc. And they can also do return to work classes. It's quite a good program. And I think that's probably where the coverage would be. So, next question. Do you offer free initial consultations? I'm wondering if I can prove retaliation constructive dismissal case. So we do free initial consultations at our firm in across the 3 provinces where we have offices, so BC, Alberta, and Ontario. There is some assessment that's done to a matter when somebody comes in, or somebody contacts us to see if they want to talk to a lawyer. So most cases I would say qualify for free initial consultations, but some don't. So no guarantee that we'd be able to offer a free initial consultation, but I would say most of the time we do, and we do a lot of them. I do probably 6 or 7 a week free initial consultations. So in general, the answer is yes. I would say reach out on our website to our intake team. And they'll look at your situation and they'll assess it, and they'll tell you what we can offer you, and they'll assign you to a lawyer, and they'll set up an appointment, and you can have those conversations from there. Next question from Sandra on Reddit. My employer says my termination pay is limited to the ESA minimums. Do I have any entitlement beyond that? So there's a couple ways that ESA is Ontario, I think. So maybe you're an Ontario employee or BC. In Alberta, we have the ESC. It's the Employment Standards Code, but same thing. There are some ways that you can be limited to those minimums. Generally, it's just if you have a contract that is properly worded and is not ambiguous. And if you've agreed to that and you got a benefit for agreeing to it, so you can be limited to employment standards code minimums. But I review tons of contracts where the employer has made an attempt to limit the employee to those minimums and hasn't done a good job. There's a lot of case law from the courts on the issue of whether that contractual language is clear enough, non-ambiguous, if it's legal, to actually limit an employee to the employment standards minimum. So, it's possible. If you have quite a bit of service and your severance entitlement is quite high under the common law, which, as I mentioned, you can check out on that employment law calculator, see what your entitlement might be. It's worthwhile getting a lawyer to look at the language in your employment contract, if there is one, to see if it is legitimately limiting you to employment standards code minimums. Language has to be very specific, and it has to be very clear. It can't be vague. It has to be very non-ambiguous. And there's also a lot of ways that in those clauses, the employer can actually violate the employment standards code. So often those contractual provisions are not enforceable. So if you have an employment contract that attempts to limit you, maybe you would be only entitled to those minimums, but there's a good chance that either if you don't have that in your employment contract, or even if you do, that it might not be enforceable. So hopefully that helps and answers your question. I have another question coming from YouTube. If I am flown out for my job in 3-month rotations, but I live in a different province, which province would I be considered to be employed by? You'd be governed by where you physically work. So if you're living in Saskatchewan, but you're flying into, Fort McMurray and working north there in one of those projects, you're governed by Alberta employment laws. So it's where you're working, not where you live necessarily. So hopefully that answers your question. And we do get that a lot. There's some of the communities kind of northern Alberta, BC, where I've had employees who live across the BC border and then drive across and work in Alberta, or Saskatchewan, Alberta. And if you're working on the ground in Alberta, you're governed by Alberta employment laws. Okay, then we have Lynn from YouTube. I was terminated after asking for a reasonable accommodation for disability. Is this allowed? What should I do? It is not allowed. The employer has the obligation to provide reasonable accommodations and to also to participate in that accommodation process and try to find you something that accommodates you. They can't just say, well, no, we're not accommodating you and you're fired. That, from the sounds of it, is a straight up human rights violation based on disability, and that the employer has failed in their duty to accommodate. They need to accommodate to the point of undue hardship. So if you ask for, you have some kind of disc problem in your back, and you ask for some kind of, ergonomically correct chair in your office, and they say, well, it's too expensive, we're not getting you that. That's not undue hardship. For them to shell out a few $100s to buy you a proper chair, that's not going to be considered undue hardship by the courts or by the tribunal, the Human Rights Tribunal. So, that's the standard. If it's something like, you need maybe changes to your hours, right? Shorter work days, whatever, those kinds of things, it has to be undue hardship. And that's a very high standard for the employer to prove. So unless the accommodation places them in a position of undue hardship, they do have to try to accommodate you, and they have to participate. They have to talk to you. They have to, go back and forth, see what they can do. So if you asked and were immediately terminated, definitely human rights violation. Reach out and talk to one of us. Like I mentioned about the person with free consultations, reach out, go to our website. Sounds like a situation where you'd be getting a free consultation. So, reach out and then see what you can do. I think that you have some entitlement there. Next question. If my employer is offering me an additional 8 weeks, but only if I sign in the next week, should I take it? Is this a pressure tactic? I am an 8-year employee, so it seems like 8 weeks is all I get. So if you're in Alberta and you're 8 weeks, 8 years, you actually would be entitled to 6 weeks under the Employment Standards Code. If you're more than 10 years, then your minimum statutory entitlement is 8 weeks. But 8 years would be 6 weeks. They then are offering you, what they're really offering you is 2 weeks additional if you're an 8-year employee in Alberta, because you have to get the 6 weeks. That's not, you don't have to sign anything to get 6 weeks. So what you're signing is you're signing for 2 weeks. That's likely not enough. That's very low. If they're saying sign in the next week, you're still going to get the 6 weeks. You have to get that. There's really no reason you have to either respond at all within a week. That is really what they're saying to you, is this is how long the offer is open. If you don't respond in a week, then they pull their offer, but you are probably entitled to more than that. So, why would you accept it in 1 week if your entitlement is to more than that? And I would say you should get that checked, because it's probably pretty unlikely. Obviously it depends on what kind of job you have, how old you are, etc. But most jobs, the notice period would be more than 8 weeks. And if you're a 6-year employee, it's probably pretty likely that it's more than, more like 6 months, right? So that seems low. I would say, don't take it. Get it looked at first. We usually say don't sign anything until you have somebody look at it. Is it a pressure tactic? I don't know if it's a pressure tactic, but they have to give you a date, right? They have to, they don't just give you an offer and go, well, yeah, it's open forever. You can sign it 4 years from now. They have to give you a date. Usually it's 1 week. They say, here, it's open for 1 more week. You can get an extension on that if you want to talk to a lawyer. They should be granting that to you, because otherwise, if you did sign, it would be considered to be under duress. So, ask for an extension if you want, but I would say have that offer reviewed by an employment lawyer to see if it is reasonable in the circumstances. Probably isn't, unless you already have a new job. If you already have a new job, then maybe it is. But, if it's going to take you longer than 8 weeks to find new work, then unlikely that offer is sufficient. Okay, sorry, I'm just scrolling back down here because I think I've where are we? Okay, we looked at that one. Okay, we have my employer's asking me to repay training costs now that I've left. Can they do that? Depends on your employment contract. A lot of employment contracts, are the terms under which you are provided with training, is subject to a repayment obligation if you don't stay for a certain amount of time. So it depends on the terms under which they paid for training. It depends on the training, and it depends on what your employment contract says. I would say I have seen in several situations that employees do have that obligation, that their employer inputs a bunch of money, and it is on the condition that they stay for 2 years or something. And then if they leave before that time, that they have to pay back, usually it's just a portion of the cost. But you'd have to look at policy. What did you agree to? What is your employment contract? It is possible that, they can try to get that money back from you. Okay, there's another question. My employer replaced me with a contractor right after firing me. Is that allowed? What makes something a wrongful dismissal is that they didn't give you proper notice or pay in lieu of that notice of termination. What happens to you after, what happens in your workplace after you're terminated? They can kind of do what they want, right? It really comes down to, did you get enough notice or severance that you were being terminated? They can do what they want as far as hiring a contractor. And that does unfortunately happen quite often. Right now, I would say, software programmers are having a lot of trouble because they're losing their jobs, and that work is all being contracted out overseas for much cheaper, and really struggling. People are really struggling in that industry to find new work because it's all going to contractors. So they can do that, but the question is, did you get enough notice of your termination to find yourself a new job? That's the question that needs to be answered, and that you can talk to somebody at our firm about, and we can help you determine whether or not you're entitled to anything more. That's really what you should be considering. Next question: if an employee has a total tenure of 4 years and 9 months, but with the same company, but across different subsidiaries, for example, previously employed in Singapore and now in Ontario, Canada, How is severance typically assessed in cases of redundancy or unfair dismissal? If the employer is offering only 4 weeks of severance for redundancy, what kind of severance range could a firm like St. Pierre Markin realistically help negotiate or fight for under Ontario employment law? Okay, well, with the caveat that I am an Alberta lawyer, not an Ontario lawyer, but I mean, the laws are somewhat similar. Um, if you were employed by the same company, it really doesn't matter whether you were employed in whatever area, right? Your term of service to that company is your term of service. If they're sending you all over the place, it's still your term of service. Um, Unless you're subject to some kind of fixed term contracts, or you're being terminated and provided with notice and then rehired. But if it's just you're moving from job to job with the same company, I don't think it makes any difference where they're employing you. It is your term of service to that company that is relevant. So if they're offering you 4 weeks of severance for a 4.5 to 5 year employee, that's definitely quite low. Like I said, it's probably more like 6 or 7 months that would be normal. Whether or not it's redundant, it doesn't really matter what the reason is. If it's unless it's a with cause termination, the reason for the termination doesn't matter, either if it's with cause or if it's discriminatory. But if it's just a simple redundancy, that doesn't affect entitlement. That just means you get the normal entitlement for your circumstances, which is based on age, years of service, level of position. Obviously, sometimes management supervisory positions, because there's less of them really, are entitled to higher severance amounts, and then the availability of similar employment. So if your job is really hard to replace, your notice period is going to be longer and your severance entitlement is going to be more. So, saying what kind of severance range could a firm realistically help negotiate? It does depend on a lot of things, but, looking at, you're almost a 5 year employee, likely you're looking at, 6, 7, 8 months, of reasonable notice. That can be changed if you have a contractual term that says I'm only going to get 4 weeks. That's enforceable. That can be changed if you get a job really quickly. Then you wouldn't be entitled to the amount of severance that would be offset by what you're earning during that 6, 7, 8 months. So it depends on a lot of things, but the negotiation would probably start at that high end, that 7, 8 whatever months. And then, we work to try to get to a reasonable settlement based on how that shakes out. If you find a new job that it can affect entitlement, we'd also have to assess whether you do have an employment contract that has contractual language in it that limits you to the 4 weeks, or why you're only being offered 4 weeks. So, I mean, that's a pretty general answer to your question, but I think, I need more information to really be able to assess what kind of notice period you're entitled to. But hopefully that gives you an idea. I would say, again, look at the Pocket Employment Lawyer, our severance calculator online. That might help you to answer that question, because it'll ask you for quite a bit more information. Looks like we have just a couple minutes left, so probably the last question from Facebook. I was fired during my probation period. Do I have any legal rights? Well, first of all, I think I would want to know how long of a probationary period did your employer put you in. In Alberta, under the Employment Standards Code, there is no minimum termination pay under the statute for the first 90 days of employment. Some employers try to make your probationary period 6 months. So, if you're in your probationary period, but you're past 90 days in Alberta, you are entitled to a minimum amount under the Employment Standards Code. Also, that minimum amount under the Employment Standards Code is just that. It's just a minimum amount. So it is possible that you are entitled to a full common law severance, even if you are only a few months employed. Some employees, there has been case law where there's one case from BC that I can think of where somebody was employed for 3 days and the court awarded him 3 months severance. So, it may be that you could get some severance, whether or not you're in probationary period, and maybe even under the code, because it might be that, that probationary period is longer than the minimum amount that the code allows. So yes, you do have legal rights potentially, to a full severance, to a full common law severance, and possibly even to the minimum termination pay under the code, depending on how long that probationary period was set at and at what point you were terminated in that probationary period. So hopefully that helps. Hopefully I've answered everybody's questions, and tune in again. We have another, we have more shows and live streams coming up. And sorry, I'm just getting sorry, I'm just getting some from another source there. But yeah, we have another live stream coming up on February 4th, which is tomorrow, 1 p.m. with Lior. Of course, he's our founding partner, so always has some good insight. So hope everybody's questions got answered today, and I'll see you again probably next month. Take care.